All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. I will now call the case on the 10:30 docket, 123-647, State of Kansas versus Anthony Darrell Allen. Counsel, please come forward.
Good morning, Your Honor. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the petitioner in this case, the state of Kansas, present and ready for argument.
Morning, Chief Justice, Justices. My name is Adam Sokoloff, and I represent appellant Anthony Darrell Allen. We are present and ready for argument.
Thank you. Mr. Gonteski, may approach.
May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the petitioner in this case, the state of Kansas. And I'm requesting 3 minutes for rebuttal, please.
3 minutes will be granted.
Thank you. We're here today to talk about Anthony Allen and his right to a jury trial and his right to counsel in that jury trial. Anthony Allen was a challenging client for the 5 appointed attorneys who attempted to represent him over the course of his case. And Allen vociferously pleaded with the district court to permit him to represent himself throughout the proceedings. After his conviction, though, Allen claimed that the trial court erred in granting exactly what Allen had requested every step of the way, and that was his right to self-representation. The Court of Appeals, acting on an incomplete record after Allen failed to designate transcripts of several hearings before the trial, concluded that while the trial court did sufficiently have a colloquy with Allen before the eventual trial to ensure that he wished to represent himself, his right to represent himself at trial was ultimately protected. But the Court of Appeals found error in that the record lacked a sufficient waiver of counsel for a pretrial period of 14 months. And specifically, the Court of Appeals addressed 2 hearings within those 14 months that the Court of Appeals found to be critical stages of the proceeding in which the record failed to demonstrate that Allen had executed a sufficient waiver of counsel before those hearings progressed.
That was res sua sponte, correct? About the hearings.
I would argue it was. The opening brief in this case that Allen filed argued that his right to counsel was violated, but it did not specify those 2 hearings. And I noted as much in my opening brief with the Court of Appeals. And then the Court of Appeals really zeroed in on those 2 hearings, the March and May of 2018 hearings.
What evidence did they use then at the time to justify what they found about the existence and what happened at the hearings?
The best I can discern from what they used was the bare ROA, the record of actions produced by the district court, which is a very cryptic document that outlines in 1 or 2 sentences at most.
Is that appropriate evidence?
I argued it was not. And I argued that in the petition for review here and in my supplemental brief, that was an insufficient basis upon which to find the trial court erred, particularly given that in the absence of a record this court has held, it should presume that the trial court acted correctly rather than incorrectly. Now, a portion of that record, at least, has been remedied to an extent. And after filing the supplemental brief in this case, after the state's petition for review was granted, I filed the supplemental brief. And after that, the parties reached a settlement of the record pertaining to the March and May of 2018 hearings. And if the court will recall, those were the hearings in which transcripts had not been produced. The court reporter was no longer available, but what the court did have was some cryptic notes are the best way I can describe them from the hearing that had been produced by the court reporter at the time, but they never got decoded by the court reporter. And so the parties requested that we requested jointly to add those to the record on appeal. This court requested that rather than add those unofficial transcripts that we conduct a settlement proceeding at the district court, and we did so.
Can I ask, just backing up
Yes.
in the procedural steps, the state has the ability to supplement the record, right? I mean, was there a designation of those records before briefs were filed at the Court of Appeals?
No, I did not request those because part of my argument in the Court of Appeals was that the appellant had failed to designate a sufficient record to establish his claim of error. The burden I was arguing was on him to establish the error, and in failing to designate a sufficient record, I did not seek those transcripts to that end. Now that we have the settlement of the record, the parties did not engage in further briefing. The state, at least on the state's part, I believe my supplemental brief that I had filed before we reached the settlement of the proceedings ended my ability to brief further these issues. But I would note, I believe the settlement of the record clearly demonstrates that in particular for the second of the two hearings, the May 2018 hearing, in which the 6455 motion was heard and the defendant's motion to dismiss was taken up. In that hearing, our settlement of the record demonstrates, I would argue without a doubt, that a full colloquy was conducted with Mr. Allen in which he definitively waived his right to counsel. The court went through exhaustively all the low factors and the dangers of self-representation and why the court always advises defendants against that course. Even the state went on the record noting that it was not a course of action that Allen should take. So in the May of 2018 hearing, I believe a full and sufficient waiver was conducted. The hearing 2 months before that, the competency hearing, the third.
Let me just interrupt you very
Yes.
quickly. I'm looking at my notes and the only thing that, what exactly are you relying on in the May 2018 from the settlement of the transcript? Is that what we call it? Settlement of the record. What are you relying on at that May 2018 hearing that tell us that it was definitively waived?
When within our settlement of the record in the May of 2018 hearing, if the court has the settlement of the record in front of it, page 3 through page 6 are the portions pertaining to the May of 2018 hearing. And in that hearing, the court went through asking Allen about his educational background. The court noted that it had been through many of this before, but wanted to walk through it again. Asked if he had any legal training, asked what Allen had reviewed in preparation for representing himself, and noted that Allen's attorney had indicated there may be motions that Allen would want to file, asked Allen if he had done research on those motions. The court asked Allen if he understood that if he proceeded to trial by himself and asked inappropriate questions or failed to follow procedure in selection of the jury or in opening statements or in closing arguments or in cross-examination, he would not be able to proceed and the court would have him sit down. The court asked if he understood that he was going to have Mr. Thomas as standby or backup counsel to ask him any questions he could at that point, and that at any point, if he represented himself, he could have Mr. Thomas take over.
How did those items compare with like the low factors?
When we go back to the low factors, while setting forth 7 or 8 specific factors, the gist of low talks about making sure that a defendant fully appreciates and understands that they have that right, but that with that right comes certain burdens or certain risks. And those risks are that you may not fully understand the law. You may not fully understand objections and how to respond to objections. You may not understand how to admit evidence or what the protocols of the court may be. And the fact that you don't understand those can be to your detriment. And when they're to your detriment, the court won't come to your rescue and the state won't come to your rescue. And so several of those low factors are basically an effort to impress upon a defendant seeking to represent themselves that doing so puts them at a deficit. And so Judge McCarthy went through many of the ways in which self-representation would be to Mr. Allen's detriment.
Okay, and then as far as the burden steps on this, whether he appreciated the consequences of his decision, is there anything in that colloquy that besides saying, I'm not going to help you and neither is standby? Or the third burden step, you understand the punishment that could happen. You understand the charges and the proceedings and the punishment and, you know, the overall facts of this case and what can happen to you. Was there anything in there about that? And I know that, you know, these aren't mandatory, right? There's no list required.
Right.
Nothing.
Right.
So when I ask these questions, they're just what you factors you can consider for
Correct.
knowing and voluntary waiver.
Understood. While those explicit ones were not stepped through in the same language that Lowe used, although that did occur in other hearings when the state provided the district court with a copy of Lowe and requested it specifically go through the Lowe factors. But in this hearing, it did not go through the Lowe factors explicitly. But in
Or the
terms of
burden factors,
I'm sorry,
or burden.
or burden factors. And when you say burden factors, you're referring to the risks that the defendant faces in representing himself.
And appreciating the consequences of the decision, yeah.
I believe those would be rolled into the court's impressing upon him that if he did not follow the rules of the court, the rules of evidence, that he would have to sit down, he wouldn't be able to continue to represent himself. And the court asked Allen again if he still wished to proceed in representing himself, and he said yes. He then later said he wanted to fire Zach Thomas as counsel altogether. Even the state went on the record in paragraphs 22, 23, noting that it had concerns that Allen would be required to operate within the rules that the state is also bound by. And the state wanted to ensure he received the fairest possible trial, but he wanted to understood that he knew the risks he was facing. And that colloquy on the issue remained important to keep checking with Allen that he was fully aware and understood those. And he continued to indicate that, yes, he wanted to represent himself.
And what
every
about
step of
that?
the way.
And the March hearing?
The March hearing was much shorter. The March hearing was the third of 3 competency hearings. And in the March hearing, I would agree, that even our settlement proceedings do not demonstrate a complete waiver of the right to counsel within the limited transcript portions that we have.
What are the ramifications then of that proceeding happening without counsel in terms of critical stage and structural versus prejudice versus harmlessness?
I appreciate the question because that's where I want to get to
Yeah,
today.
sorry.
No, do not apologize. That I believe is the crux of what the court has in front of it today. That the state acknowledges was a critical stage. A competency hearing is a critical stage of the proceeding under Ford and other cases. But he was never prejudiced because he was found competent in that hearing as he had been at the previous hearings. And he never contested that he was competent. He never raised competency at the Court of Appeals. He never argued at any phase of this case, he has never argued that the trial court erred in finding him competent. And because it was and I'm recognizing my time is exhausted, may I continue to respond? Thank you.
Yes.
This issue of the deprivation of the right to counsel at a pretrial proceeding that is ultimately corrected before the eventual trial or plea lends itself to the harmless error analysis and should not be deemed structural by this court. It lends itself perfectly to the harmless error analysis because we can step through how could that proceeding have been better for Mr. Allen. Likewise, with the May of 2018 hearing, we can ask what prejudice befell Allen by virtue of him not being represented at that hearing. When we look to the March hearing, it was that he was found competent. When we look to the May of 2018 hearing, His motion to dismiss the case was denied. It was a one-page motion that entirely lacked merit. The court can see that motion in the record on appeal. The district court and the Court of Appeals acknowledged without issue that that motion lacked merit on its face. So his motion was denied. In that May hearing, the state sought to admit 6455 evidence against the defendant, and the state's request was denied. So when we look at those two hearings,
Actually, part of it was deferred, wasn't it?
it was
It was either denied or deferred.
until, correct, until trial, correct.
But why would we look to the merits of a pro se motion as the measurement for harmlessness? I mean, isn't that the very reason you'd want counsel? Or is it too speculative to say whether what counsel could have done in that instance in terms of dismissal?
The motion was a pro se motion that Mr. Allen wrote himself and filed with the court. And before the trial was conducted, a full and complete waiver was done. So when counsel, either when counsel stepped in or after the waiver was complete, there was still a continued ability to file any motions that any party would request. And the reason why this should not be deemed structural error and automatically reversible in every instance is because in a pretrial proceeding such as these, we can examine harmlessness and it does not infect the trial itself. The trial itself is where we examine the right to counsel. And that the crux of all of this, what all of this is leading to is the trial.
Okay,
And
I'm gonna push back a little bit on that. On the competency hearing, the state was the one who suggested to the court that there should be a competency hearing. And the court agreed to order the competency hearing. So at some point that lends itself to an implication that at least the state and the court were concerned enough that they got the competency hearing. So then we know that he was not represented by counsel at the competency hearing. So the difference between whether or not we can make a determination as to harmlessness, as I understand the Supreme Court cases, is that we have to be able to determine that we cabin the error to only that one hearing and that it does not affect or taint or infect subsequent hearings or the structure of the trial itself, of the proceedings themselves. So this is my question on that. Some circuits say, well, you can have a harmlessness analysis, including the 10th Circuit. We can just send this back and say, okay, a couple of questions, go through this 4-factor determination to determine whether or not we can have a retroactive competency hearing to begin with. And then if so, have that competency hearing with benefit of counsel and determine whether or not this person is competent. In this case, that did not happen. So then with regard to the request or the waiver of counsel, there's an additional test for competency, which is before you can even ask the defendant whether he wants to waive counsel, there's a presumption that he is competent to make those determinations that I would argue are a higher level than simply being competent to stand trial. So what is your best argument that what was done at the competency hearing that was to find that lower level of competency without benefit of counsel to ask questions, present witnesses, or to do any of those things? What's your best argument that that didn't affect that next hearing, which also addressed the higher level of competency to waive counsel?
I don't believe any error in the March competency hearing would have infected anything that occurred in May, because we know from the record as it marched forward that a complete waiver was done repeatedly in the months that followed before the trial at multiple hearings. And we know that Zach Thomas, who was, I'd argue, more than standby counsel, Zach Thomas was at Mr. Allen's side through the entirety of the case at every hearing. He frequently entered his appearance. He spoke about visiting Mr. Allen in jail, discussing motions with him, providing him with legal research. And after the court found him competent at the March 2018 hearing, no one raised a flag about competency in any way. Not defense counsel, Mr. Thomas, not the state, not the court. And repeated waivers that occurred before the trial evinced his competency to waive that right. By virtue of the record that we have that shows him responding to the court's inquiries and appreciating the consequences of his decision, understanding the nature of the case, understanding the risks, understanding the potential sentence that he faced, and so on. And even when we got to trial and he began by representing himself, he then requested partway through the trial that Mr. Thomas come in and represent him full on and conduct some examinations of witnesses. And so there's nothing in the record that would indicate the court's determination on competency from March of 2018 was in any way incorrect. Likewise, post-conviction, when the case went up to the Court of Appeals on appeal, Allen never claimed, with the help of counsel, with the help of appellate counsel, Allen never claimed that the court erred in that competency hearing or that he was incompetent or procedurally somehow failed in protecting his rights below.
Why would he if he's incompetent?
Because he was represented further on and there were individuals there to raise that issue if it in fact was a meritorious claim, and no one ever did.
Here's my issue, okay, in putting it in its simplest terms, explain to me. If in March, he is determined, as you say, he's determined competent without, with right to counsel being deprived, and competency, as you say, is never raised again. And so then he gives up his right, you could say, for purposes of your argument, we'll say in May of 2018, although I'm not sure, but definitely later, in July of 2018. So when he gives up that right in July of 11th of 2018, we don't know whether, we still have this erroneous issue of whether, we have the error that permeates, now it's permeating everything. Because when he gives that up in July of 11 of 2018, he could be incompetent. We don't know because we deprived him of his right to counsel. And then he goes into trial representing himself, permeate. It does seem like it's structural error and that can't be analyzed because structural error is that there, it affects and permeates the entire trial process.
We need not assume that what occurred in the March of 2018 hearing was erroneous and permeated anything when we have 3 competency evaluations that were conducted where doctors repeatedly found Allen competent. And then the court itself repeatedly went through colloquies that were more extensive even than Lowe in discussing all of the competency question.
Then why did the judge order another competency hearing?
Because I believe the state requested as
Exactly.
The state requested as much based on observations of him in the courtroom and so on.
Right.
We have.
But the competency question itself, if you look at the competency evaluations, what they examine are things like appreciating the roles of the parties, the risks he's facing at going to trial, what a potential exposure is, what the role of the court is, what the role of defense counsel is, what his role is, how witnesses will be presented, right from wrong. All of these sorts of questions that get asked in a competency evaluation are all rolled into the colloquies, the repeated colloquies that Judge McCarthy had with this defendant in the run-up to trial.
Right,
And
but
s-
if,
and so
but
even
that's
if-
not taking into account what happened in March, that he was deprived of his constitutional right to counsel at a what are we calling it? A critical point of trial, stage of trial.
Well, that would seem to discourage the state from ever requesting a competency evaluation. To
No,
assume that it would be structural error if he was deprived of his right to counsel in that scenario. But in any event, what we have is, I would argue, even better than a competency evaluation from a doctor that went and visited him in jail, which is we have these extensive colloquies that took place between the defendant and the court in the lead up to trial to know whether or not, if an error had occurred in March and he was somehow, if we're going to assume he was incompetent at that point, which it seems as though the court wants to do, even if you assume as much, you can look at the record that took place after that and in the run up to trial.
then why would we ever request a competency hearing if a judge can determine competency without the finding on the record?
But
Based on,
But the judge still had the competency evaluations from the doctors
but
who
the
are,
defendant was not represented.
he represented himself.
We agree, though, that at a competency hearing, someone must have counsel.
It's a critical stage of the proceeding in which you have a right to counsel,
Well, it's a competency hearing.
right?
State has already, I mean, there's already a question of whether he's competent. So it would seem that we can agree that he must have counsel at a competency hearing, right?
I would agree.
Okay, once competency is found, for all subsequent hearings and subsequent stages, competency is presumed, correct? We have
Correct.
case law to say that.
And it's presumed from the outset of any criminal case.
Right, so but after the competency hearing, it's presumed, because that changed. When there was a request for competency hearing, it was no longer presumed, it had to be proved, right?
If that's the position this court would take, that will disincentivize individuals from requesting a competency evaluation.
Why?
Okay, well, what if it does? I mean, if, at the competency hearing, if there is a finding by the district court that the defendant is competent, then that finding of competency remains until he is proved to be incompetent, correct?
Until another,
Right.
until another competency evaluation or so
So
on.
all the subsequent hearings and all of the colloquies that had to do with his Sixth Amendment right to counsel began with a presumption that he was competent, correct?
Correct.
And just skipped over that part of it to go to the colloquy and to the waiver, correct?
Correct. But we have absolutely nothing in the record demonstrating him to be incompetent. We have an evaluation from a doctor that's part of the record that the court accepted in a hearing in which the defendant was present, in which the court found him to be competent and
And-
stamped.
And you believe that can be fixed if we go back and retroactively have a competency hearing with counsel?
That would be one way, but I believe it could be evaluated under a harmless error analysis, which is the gist of what the state's requesting here today is that it not always be deemed structural.
Without
The-
doing it again?
The state can certainly do it again. If that is the approach that this court would request to ensure that it was done the right way, the state's absolutely open to that.
Here's my concern with your position is that basically what you're saying is that subsequent determinations, subsequent hearings, when Mr. Allen was deprived of his right to counsel, can be cured later by some procedure.
And other courts have found as much and other circuits have found as much, and the United States Supreme Court has found as much.
Why does any right to counsel attach, or what's to prevent kind of what's to prevent what happened here? Or even his appearance at a competency hearing, if it can be later cured. How do we address that?
There, it's addressed by the body of case law that says it's a critical stage of the proceeding. He has a right to be there and has a right to be represented. And there's still the harmless backstop. I'm not here arguing from the get-go that you should just find a defendant can be waived of counsel at any pretrial hearing as long as it's remedied before trial. That's not my
Why
argument.
aren't you arguing? It seems to me that's what you're arguing.
That's not what I'm only arguing, that in a pretrial proceeding where a right to counsel is deprived, it should not be deemed structural to have infected the ultimate trial as if it was remedied before the trial or the plea. The court should at least examine harmlessness. That's not to say the state would always prevail. That's to say that the impact of it and whether or not the defendant was prejudiced by it should be considered. If he came in for that competency hearing on Monday morning at 9 a.m. and counsel didn't appear because they were late and the court said, we're going to go for it anyway. I've read the report. State have any objection to it? I'm going to find him competent. I find him competent, and off we go. And then at 2 p.m. that day, counsel shows up, says, I lost my calendar. I can't believe I missed that. And the court says, I found your client competent this morning. We're going to go on next week. We're going to have another hearing, XYZ. Under the structural error analysis, his trial would be infected by that. We'd be reversing a trial in which this woman testified about having been kidnapped and held for a month.
No, they
And we're
would
going to
have
bring her
another,
back years later.
no, the judge would say, okay, well, we'll have another hearing so you can raise objections to the report if you have them on behalf of your client.
But if
That was never happened here.
it didn't happen here, but he had counsel at his side in these hearings who could have said as much if he believed as
He was
much was
stamped by
necessary.
counsel. It wasn't his counsel. He was self-represented. And that's the whole point. What I'm talking about, the difference between structural and harmless is it infects the whole trial. And in the hypothetical that you're giving, it wouldn't, because it would have been remedied by saying, oh, I understand that that you had a time thing. Let's, you need to have an opportunity on behalf of your client to object to the report and tell me what you think.
And examining that remedy that happened later in the afternoon would go in a harmless error analysis. Because if that's the way it happened, it would still be that the morning hearing was a critical stage in which he was unrepresented. And under structural error analysis, it would unwind everything.
So
If
am I correct in understanding your argument to be that the difference between structural error and harmlessness in this particular fact scenario is in fact the merits of the competency hearing? In other words, if he was competent in March of 2018, then it's harmless.
Absolutely.
If he was not competent, it's arguably structural.
I
And
wouldn't
this is
argue
the-
it's structural. I would argue that the harmless error analysis would demonstrate he had been prejudiced and thus the conviction should be reversed.
But the
It-
key
but-
question is, was he competent in March of 2017? And this is what we don't know. And so the question's already been asked, but it strikes me I'm just wondering why you're not arguing for a retroactive hearing.
And if that is, I'm arguing that it shouldn't be structural, because if it is, we don't even get a chance at a retroactive hearing. I'm arguing it should,
But my point is it's circular. The two things are intertwined. You can't decide whether it's structural unless you first know that he was incompetent.
understood. The state would be absolutely open to and welcome a retroactive competency hearing to evaluate the defendant's competency in March of 2018. If that is an avenue by which the state could demonstrate, in fact, he was competent, no error befell him, he was not prejudiced by the lack of counsel. And that's why I put it under the umbrella of a harmless error analysis. If we stick to a structural error analysis, I don't believe the state ever even gets to request.
I'm just suggesting that this court, at least arguably, cannot even decide which rubric to apply, which reversibility rubric to apply, unless you first have the factual question answered.
Then to that extent, if the court is struggling with that question, I would welcome the
That
case
might be the
being.
only one.
No, understood. But if this afternoon it's decided that that's the avenue, the state would welcome a remand to the district court to conduct a retroactive competency evaluation going back to the March of 2018 hearing. That's absolutely, and to answer the question as to why the state hadn't, that wasn't an avenue the state was pursuing. Frankly, I just didn't see it. In that I felt as though being cabined to structural error, I would never get a chance to request as much anyway. So that's why I've pushed back on